Thanks everyone for coming. I'm going to stand because I'm more comfortable standing because I am in court more often than I should be. How do I advance it? Just because I don't know the technology. This one? Right and left. So my name's Erica Probst. I'm an attorney in Columbus, Ohio. I do employment law. I focus generally on the areas of discrimination, age discrimination, race discrimination, gender discrimination, FMLA work. I do a lot of work in the SPVR with respect to state employees who have been terminated. And I'm here today really to talk about the effect that COVID-19 has had on certain federal and state statutes that we use every day, specifically the ADA and Title VII. I think that COVID-19 hasn't so much changed the statutes, obviously, but it's changed the way they're being interpreted. A lot of this is still we're working through it because the pandemic was in 2020, and as everyone knows, the justice system is not swift. So people who have lawsuits filed associated with COVID-19 mostly are still pending, but we do have some decisions that I think are really important that I want to talk about today. So what I want to talk about really is COVID-19 in general. Is it a disability? And go through some decisions that have discussed that. COVID-19 in general was a virus, if you will, and generally transitory or temporary illnesses are not disabilities. However, there is a new term that came out in the midst of the pandemic called long COVID, and that is causing some issues on whether or not COVID-19 is in fact a disability or would trigger an individual's rights under the ADA. I also want to talk about attendance requirements. As you will hear a lot today, a lot of the country went remote in 2020, and we had some emergency FMLA acts passed associated with quarantining and attendance, and most of those have expired. However, we're still having attendance issues. I have employers call me. I represent some employers. I do 90% of plaintiffs' work, but I do have some medium-sized employers who call me about employees who just aren't coming to work because they're sick with COVID. And how long can they stay out, and when can they fire them? And that's a very good question. We're also going to talk today about some things that came up in the COVID era, testing requirements. Now, generally speaking, when people would go to work, you wouldn't have them tested for the flu before they walked in the door. Now you're seeing people getting tested for COVID-19 before they can walk into work. Is that allowed? And how long can it go on? Vaccination requirements. Again, there are vaccination requirements in various employer situations throughout the country, schools, etc. Is the COVID-19 vaccination requirement that has been put down by various private employers and by some municipal or states, is it legal? And then I guess I have a summary at the end, but not sure what that's going to be. All right. So generally, let's talk generally. Is COVID-19 even a disability? So as I said, generally an illness or an impairment that lasts less than 6 months does not qualify as a disability pursuant to the ADA. Generally speaking, when you were talking about quarantining, when you got COVID, you were going to be out about 14 days. And generally speaking, that would not qualify as a disability. A 14-day illness is transitory, and it is not a disability and has never been a disability. Then came a term they used called long COVID. And long COVID was, I guess, I have not had long COVID. So long COVID, based on my understanding, is COVID that extends beyond the normal period and debilitates individuals to the point where they're out for 3, 4, 5, 6 months. It's generally associated with another illness or inability really to function, lung diseases. So the EEOC, based on that, opined that COVID-19 may, in certain circumstances, be considered a disability and thus require or trigger the accommodation standards set forth in the Americans with Disabilities Act. So generally speaking, whether or not COVID-19 is a disability depends on the symptoms associated with the particular individual who have it. Long COVID is definitely considered a disability, and it has been determined that it is a disability. So for purposes of this exercise, I want to kind of talk about specific case-related issues that have come up in my practice and may come up in yours. And we have two specific cases today that involve COVID-19 diagnoses where individuals were going to be out beyond the quarantine periods allowed and were terminated. In those cases, the ADA issue of COVID being a disability was discussed, and in one case, they're nearly identical, honestly. Both individuals had COVID. Both individuals were terminated within the quarantine period because their COVID illness was going to extend beyond it. And one court found that COVID did trigger the disability protections under the ADA, AA is actually what it's called, and that one did not. Why? I'm not really sure why the court made there are two different courts, obviously, or why there's a distinction, but you're going to see this as we move forward. There is no real understanding of whether or not COVID-19 is a disability. So one court found that it may be, and the other court found that because the individual who claimed to have COVID-19 did not provide any details of his symptoms, the employer's termination of him within the 14-day period was valid. I have had one client call me who's an employer, a towing company, who has a dispatcher who was sick. And that particular dispatcher had COVID-19. Her illness went well beyond the 14-day quarantine period, and he wanted to terminate her. He, in fact, then said, listen, you're unavailable to work. Let's get unemployment, and then call me when you're able to work again. So she sued him, claiming that he had fired her in violation of the ADA and that she had, in fact, a disability. That there has been no determination on that case yet, but the defense obviously is that her illness was transitory at the time, and she eventually did not have COVID, and her period of COVID was less than the 6-month period. Based, though, on her symptoms, and the effect that the virus had on her, she could not return to work and didn't return to work. We'll see what happens, but based on these two cases, there's not really that much guidance except to say that it may be a disability. So when you are dealing with an employee who calls in and says, listen, I have COVID-19 and I may not be able to come back to work within the quarantine period because I can't breathe, I'm on a breathing machine, or for whatever reason, their symptoms prevent them from coming back to work. You really have to think about whether or not the ADA is triggered. I don't know how long that's going to last because generally COVID does not last 6 months. I really don't. I find these two cases interesting because they're so different. So again, employers should be aware that COVID-19 may be considered a disability, and employers are required to make reasonable accommodations for disabilities. Not all COVID-19 infections are disabilities, and employers should consider the risk of exposure to others in the office from that infection severity based on how severe it is. Given the case law, though, it appears as if your employee doesn't give you any details about the severity, you have no reason to believe that the ADA is implicated or that it's a disability. The next question is, can employers continue testing their employees for contagious illnesses, specifically any contagious illness outside of COVID-19? Can we test for the flu? Generally, the testing requirements that have been put in place by a lot of employers are viewed as an accommodation to the COVID-19 vaccine mandates that allow employees to continue to work without getting a vaccination. employers who require employees to be tested, these tests or these requirements, they need to be reasonable, they need to be enacted for legitimate purposes, and they need to be non-discriminatory. Certain testing requirements could have a disparate impact on individuals that have religious beliefs or disabilities, and it is evident that courts across the country require employers to provide exemptions, religious and disability exemptions, and one cannot be preferred over the other. Meaning an employer, if you're going to grant an exemption, you cannot say, well, I'm not going to grant religious exemptions, but I'll seriously consider your disability exemptions. You just can't do that. All right, so specifically related to the vaccine, there are employers, and you've seen it all over the TV, across the nation that have required their employees to be vaccinated, whether they be public employers or private employers. A lot of medical facilities across the country have required their employees to be vaccinated. There have been mass terminations across the country. In fact, I have more than 40 vaccination cases that I'm handling right now for individuals who have been fired nationwide resulting from a vaccination mandate. The cases that I have right now, there were no exemptions offered. So we're going to take those up. Having said that, what about, is there a difference between public employers and private employers with respect to the vaccination mandate? No. These exemptions that are required, these religious and disability exemptions, public employers and private employers are both expected to offer these exemptions and to consider them in light of the mandate that they have put in place. So, the first case that I have here is and I'm not going to pronounce it. It's Unifis SCC versus Cody. It was in 2022. It's fairly recent. And the court indicated that employers cannot prioritize employee exemptions for disabilities over religious or vice versa. If you're going to offer an exemption, which is required by the ADA or Title VII, you have to consider both classes of exemptions. You cannot say for any purpose, well, that religion isn't real, but we'll consider your ADA exemption because you have a disability that has never allowed you to be vaccinated. In Kane versus de Blasio, employers cannot limit religious exemption requests to established religions or use general stereotypes to deny religious exemptions. This case is out of New York, and in that specific case, with respect to New York City, it had indicated that it was going to deny religious exemptions for religious groups whose leaders had come out and said, we're okay with the vaccine, we're going to encourage our parishioners or worshipers or members of our church to get vaccinated. But the individual who happened to visit that church, still holding on to what they believed to be their religious belief in that same religion, said, I do not want to get vaccinated. The court said that New York City's denial of religious exemptions based on one individual's thought process of how that religion should accept the vaccination, whether he be a religious leader or not, was unacceptable, and that their failure to then consider those religious exemptions for people who are part of that religious leader based on somebody else's thought process or belief was a violation, and therefore it was disallowed, saying that portion of the mandate was not valid. So when you're talking about a religious exemption, it is about that person that makes the exemption, that requests the exemption. It's not about anybody else in that religion. If you're Catholic, a lot of individuals who I worship with at my church did not want to get vaccinated. A lot of individuals who are Catholic did get vaccinated. However, simply because other individuals in who are Catholic and in my church did get vaccinated doesn't discount the individual who actually believed that Catholicism does not allow vaccinations. And this case goes a long way in reaffirming that that part of the religious exemption. In Wise versus Inslee, which is a case in 2021, a vaccination mandate for state employees did not violate constitutional or statutory rights because the state had a compelling interest in preventing the spread of COVID. So in that specific case, they said, yes, the vaccination mandate is valid, but you do, in all of these cases, they did indicate that you must consider exemptions. You had Vacina versus the United Airlines Incorporated. United Airlines was requiring vaccines and also had a mask mandate. In this particular case, the mask mandate at United Airlines has been in place for over a decade. And so for communicable diseases, United Airlines employees always had to wear a mask if that ever happened. So this particular case where they found the mask mandate reasonable and unenforceable, the particular plaintiff in this case had worn a mask before for other communicable diseases, and he had never objected, but now was objecting to the mask mandate for COVID-19. This is a bad plaintiff. I don't think that this particular plaintiff had any grounds to move forward. So the underlying mask mandate that was made and vaccine mandate was found reasonable and enforceable because United Airlines' original policy was based on consistent medical evidence, and they continued to enforce it regardless of the fact that the underlying communicable illness, disease, whatever you want to call it, had changed. In Sadler versus Tyson Foods, this case is interesting. The individual who sued had actually gotten the vaccination, and he had lost his vax card. He did not object to the mandate, which they had put in place, but he could not establish by using a vaccination card that he had actually been vaccinated. So he went to his doctor, who gave him the vaccination, both shots, took it to Tyson with his medical records and said, here, I've been vaccinated. Please accept this as proof that I have complied with the vaccination mandate. And Tyson Foods said no, and they fired him. So happens that at the same time, this particular individual had a workers' compensation claim pending, and so the court found that it was likely a retaliatory discharge associated with that. But this goes a long way in establishing that you can have a vaccine mandate in place, and it can be reasonable, but if the individual substantively complies with the mandate, meaning they didn't object to it and provided evidence of it, even though it wasn't in the form required by the employer had to accept it. In Clark versus Jackson, this is another case that occurred in 2022. The court found that under the 14th Amendment, there was no absolute liberty interest in refusing what they believed to be mandated medical treatment. The court found that the hospital's vaccination requirement was reasonable and that it passed the rational basis test because it applied to everybody equally. In this particular case, the plaintiff didn't have a religious or a disability issue. He simply just didn't want to do what his employer told him to do because he believed that he had the right to control his own body. Right or wrong, the court found that he didn't apply for an exemption, one that the courts require employers to review, and therefore he lost his case. Because had he applied for an exemption or had he had a disability or a sincerely held religious belief, the employer would have had to consider it. All right. There are several state statutes that have been put in place, some before COVID-19 and some after COVID-19, relative to vaccinations. There is one in Maine which was quite interesting, and I want to make sure that we talk about that. Just let me. Maine has always had a statute that requires hospitals and healthcare facilities to ensure and maintain the physical and health integrity of their buildings and their employees. It's been in place since 1989. And based on that statute, a lot of medical facilities in Maine have required vaccination against communicable diseases. In 2021, they amended the statute to include COVID-19 as a communicable disease. But they removed the religious exemption from the list of exemptions that an individual could have to the COVID-19, to the vaccination. And they did it only for the COVID-19 vaccination. Strange. So what the court did was it said that the statute in and of itself was proper because it passed the rational basis test. It indicated that when the legislature altered the statute in 2019 to include communicable diseases, and their goal was to further crucial public health needs. Then, by adding the COVID-19 vaccination for healthcare workers, the state of Maine sought to protect the public health, and exempting individuals whose health would be threatened if they received the vaccine was an essential part of maintaining the public health. What they said with respect to the religious exemption, when they removed the religious exemption in the rule in April of 2021, this change, they indicated, though it may affect the plaintiff's livelihoods, does not prevent them from staying true to their professed religious beliefs. This seems to conflict with the other cases that have said you cannot prioritize a disability exemption over a religious health exemption. This is the only state that I have found that has upheld, this is the only case I found that has upheld that kind of prioritization, that difference in a statute. And that's why I found it the most interesting, because they actually affected the change during COVID. So it was clear that they were focusing on something associated with that illness, and they made the change specifically to the religious exemption. This case, again, is quite recent. It came out in 2022, and whether or not it will stand, I don't know. But this is out of Maine, and it seems to differ state to state. For example, in Tennessee, they recently passed a statute that allow individuals to say, if you don't want to be vaccinated, you don't have to be vaccinated. So prior to the passage of that statute, the employers who employed individuals in Tennessee could require their employees to be vaccinated. But once the legislature passed that statute, they removed the vaccination requirements, although they recommended it, thus deferring mostly to the legislature, because there is a case out of Tennessee where an individual didn't get vaccinated, but did not have, that's actually not correct. They did get vaccinated. So the individual in Tennessee did get vaccinated, but they objected to Tennessee's requirements relative to proving that, to him wearing a mask, and Tennessee said, well, you're not objecting to the vaccination, so you actually can't move forward under that statute. But anyway, it's an interesting statute because some employers who have a base of operations here in Columbus, Ohio specifically, who hire individuals all over the nation and have a vaccination requirement, have changed their vaccination requirement to exclude these states that are passing these exemptions. All right, so I want to quickly go to the university case, which is Dahl versus the Board of Trustees of Western Michigan University. So in that particular case, you had a university that was a public university that was requiring only student athletes to be vaccinated, but it was required, the rest of the students that attended the school did not have to be vaccinated. In that particular case, the vaccine mandate for student athletes was struck down. They said you cannot come to court and claim that there is some different risk for athletes than there is for non-student athletes who are roaming the university, much like these student athletes, and that it violated their rights. They weren't even considering religious or exemptions or disability exemptions. It was a flat out, you don't get vaccinated, you don't play sports from Western Michigan University. And that particular case indicated that they struck down that vaccine mandate. Okay. So I wanted to go to the end super quick because my time is up, but does anyone have any questions of me?
Yes, Erica, I appreciate you shifting to the questions, and Helen Robinson, who was scheduled to be here, had a schedule conflict come up this morning. She might be able to join us later in the day, but yes, I'm glad you switched to questions because hopefully you've got some questions out there, and we've got a few minutes for that, and then we'll kind of move up our next program. And I might also warn you that since we're going to move up our 10:15 segment a little earlier, we won't forget you on the coffee. We'll have the 15-minute break right after that. So again, we've paid for all that coffee. We got to make sure you get access to it, but let's have a couple good questions for Erica.
Sure.
In Ohio, do they allow for conscientious exemptions for vaccines from the Probst? Because I know, like in school districts, they do allow parents for conscientious decisions. I wasn't sure if that was something that was allowed just in the state of Ohio for conscientious.
For employer,
For employer,
I have not heard that I haven't heard either way, honestly. It's not been litigated. I haven't had that question come into my office.
Okay.
So my answer would be, by conscientious, do you mean religious?
Could be whatever. I mean, I think from a school district standpoint, for parents in the state of Ohio, you do not have to follow the vaccine requirements,
right,
and you can choose conscientious reasons.
I agree. I understand. I don't know. I don't know the answer as far as the employer-employee. I've never seen anyone ask me that, and I haven't looked at it.
Okay.
But I would assume the answer is, if it's based on a religious objection, that they would have to consider the exemption.
Okay. And then another question is, have you seen an actual diagnosis for long COVID? Has anybody, is that being diagnosed now?
Yes.
Okay.
I have too. Yeah.
Erica?
Yeah.
So,
You go.
is it possible to get a copy of your PowerPoint? I had trouble reading the print on the screen.
Yeah. I can email you a copy of it.
That'd be great. Thank you.
Can you give me your email? Or you want? I'll get it later.
Yeah.
You can give it to everyone. Okay.
Gary, I will have all of this posted on the website. It's actually ready to get posted now, so you'll be able to pull it from the PBR website. And there's a mass mailing going out to everyone as well. So copy of bios, materials, PowerPoint, I think there's a survey and a couple other things. So, as well as the recorded video sessions. Those will all be circulated in the next week or two.
So can an employer ask for a copy of the positive test whereby, like, an employee says, I've tested positive, so I need to quarantine?
Yes.
Okay, and what if it's a, like, at-home test?
You mean where they would take a photo of it? I mean, generally if it's an at-home test, are you asking, is it okay to ask if it's an at-home test? Or are you saying, I don't trust an at-home test, I want to require my employee to go to urgent care and get tested there? Is that the question? I just want to make sure I answer it.
Well, it could be the question now that you brought it up. So, yeah, then yes, both of them, because we have employees who say, well, I've tested positive, I took an at-home test. We don't know if they took that months ago, or if they took it that day. So at that point, can we say, well, we need proof of the date? How do you know?
So generally what I tell people and what we do, even at my office, and what the courts do for example, individuals who have an arraignment but have tested positive for COVID, they require proof of a test from a location, like an urgent care. Okay, so you showed me your at-home test. Can you get somewhere and get another test tomorrow or later today if you're physically capable of doing it? Meaning, if you're well enough, can you go to one of those locations, make an appointment, and go in and get a test? You can ask them to do that. That is not an undue burden. That is not unreasonable at all.
And if they say no,
If they say no, I won't do it, well, that's another issue. I mean, I guess I would sit down and talk to my employer client and say, I would go over some things about the employee, like, do they have a track record of not coming into work? How many times, a historical review of that particular employee. If it's somebody, I think that's going to be a case-by-case basis. I don't know why an employee would say no. I think that I would seriously consider some form of a disciplinary action for not going in and getting tested at your local urgent care, especially if you offer to pay for it. Generally, COVID-19 testing isn't, you're not charged for it, but if you offer to pay for it or do something like that, which most employers do, I think you would be fine in saying, if you don't go do this and get tested, we're not going to consider this a COVID-19 related illness. I think you're okay doing that. I would think I would be okay with saying, if you don't go do this, we're going to consider disciplinary action, because this is what the policy requires. A lot of fake at-home tests have been used by students. My own son attempted it at one point with an old COVID test. Employees, litigants, criminal defendants, it's widespread. So I don't think there's any problem with it at all. And I don't think there's any problem with considering discipline if they won't, go down that path, unless they're very physically ill, like can't get out of bed, can't breathe, that kind of thing. Mm-hmm. They should be at the hospital anyway, maybe, but I don't think there's any issue with it.
I have a question about, because COVID-19 vaccine became such a political statement and a political issue, if people had participated in vaccinations prior to COVID, but now want to claim a religious exemption just for COVID, is there any connection to what they have historically done and their religious belief versus the COVID?
That's a really good question. My answer to you would be that people's religious beliefs can change. As a plaintiff's attorney, I would argue that people's religious beliefs can change. However, I will tell you that that particular type of evidence may be admissible to establish they don't have a sincerely held belief, but it doesn't necessarily mean they don't. Okay, so it is, to say it's not political is to ignore the elephant in the room, because it's political for everyone involved in it, I think, at this point. But a sincerely held religious belief can change. You can switch religions, nowadays. So it would be admissible for consideration that potentially they posted on Facebook related to the vaccination, related to a political party, that they've been active in social media downplaying the COVID-19 pandemic, maybe referring to it as a plandemic, whatever. You could use that, but does it completely negate the request? No. You do have to treat it as any other religious request, exemption request, and determine whether or not they have a sincerely held religious belief.
But the religious belief doesn't have to be that of the religion they belong to. For example, being Catholic, there is not a mandate against vaccines, but if I held that as a Catholic, that I shouldn't be vaccinated as a Catholic, then I can still use that right.
Correct. You can still use that. And in fact, you could point to a place in the scripture where, you think that that's what this means. That's all it has to be.
I'm wondering if, because COVID can be transitory and then can eventually turn into long COVID. If you've seen any cases adjudicated where an accommodation has been denied and then later turns into long COVID and the case be adjudicated.
I'm in the middle of one right now, and I can let you know how it works out. But on the employer side, but no, I haven't. Long COVID isn't common, but it exists, and it has been diagnosed. So I think that as far as an adjudication, I haven't seen one, or I would have brought it up here. I'm interested myself. It also triggers a statute that we haven't discussed, which is the Family Medical Leave Act, depending on the size of the employer. So I don't know. I haven't seen one. I can't answer. I wish I could. Is that good?
Thank you, Erica. Appreciate it very much.